Ready to strengthen your reading comprehension? Take a listen.
Have you ever wondered how a trial can be won before it even really starts? Well, today, we're going to pull back the curtain on a super powerful legal tool that works behind the scenes. It's called the motion in limine, and trust me, it's a total game changer that happens before the jury even steps foot in the room.
I mean, really think about that for a second. How do you win an argument before your opponent even gets a chance to make their point? In the high-stakes world of the courtroom, this isn't some kind of clever trick, it's a core strategy. And it's all thanks to this one fascinating legal procedure.
Okay, so what exactly is this thing? The best way to think about it is to imagine a gatekeeper standing at the entrance to the trial. That's pretty much what a motion in limine does. It's a formal request made to a judge that sets the rules of engagement and can completely shape the outcome of the entire trial from the get-go.
Let's make this even simpler. Picture a bouncer at a really exclusive club, right? That bouncer is the motion in limine. It stands right there at the courtroom door, deciding which pieces of evidence get to come inside and be seen by the jury, and which pieces are told, sorry, you're not on the list tonight.
Now, the name motion in limine, it sounds a little intimidating, a little complicated, but like a lot of legal jargon, it comes from Latin, and once you know what that means, it all clicks into place. So let's break it down.
The key word here, the one you really got to focus on, is pre-trial. This isn't something that happens in the middle of a dramatic courtroom scene with the jury watching. Nope. This all goes down before any opening statements, before a single witness is called. The lawyers argue it out with the judge, completely out of earshot of the jury. It's basically like setting the ground rules before the game even starts. And that brings us right back to the name, in limine. It's Latin for at the threshold. And that's just a perfect description, isn't it? This motion is made right on the doorstep of the trial, just before all the action really begins. But you might be asking yourself, why go through all this trouble beforehand? Why not just yell objection during the trial? And the answer to that really gets to the heart of what this motion is all about: protecting the jury and making sure the fight is fair. Here's the thing you absolutely have to understand. You can't unring a bell. It's just impossible. Once a jury hears something they weren't supposed to, even if the judge immediately says, strike that from the record, disregard that, the damage is often done. That little bit of information can get stuck in their heads and unfairly color their decision. This motion is designed to stop that bell from ever being rung in the first place.
So let's get specific. What kind of stuff are we actually talking about blocking? Well, think about a defendant's criminal history. The jury is supposed to decide this case based on this evidence, not on some mistake they made years ago. Or what about really gruesome photos from a crime scene that are just designed to stir up emotions instead of prove a fact? Even something like mentioning that a big corporation has insurance coverage could be blocked, because you don't want a jury thinking, oh, they've got deep pockets, let's award more money. It's all about keeping the trial laser-focused on what's relevant and fair.
But here's where it gets really interesting. This isn't just a defensive shield. It's also a powerful offensive weapon in a smart lawyer's playbook. A successful motion in limine lets one side control the entire narrative of the trial before their opponent even has a chance to speak.
You see, a successful motion lets a lawyer basically shape the battlefield. They know exactly which topics are off limits for the other side. So for example, let's say it's a car accident case. The defense lawyer finds out the person suing has a totally unrelated conviction from 10 years ago. It has nothing to do with the accident, but it could make them look bad. Well, the plaintiff's lawyer can file a motion in limine to block any mention of it. If the judge agrees, that whole line of attack is just gone. The other lawyer can't even hint at it. Plus, this makes for a much smoother trial. Nobody likes sitting through constant objection, interruptions. It annoys the jury. By settling these fights beforehand, everything just flows better. It gives the lawyers a clear roadmap for how to build their case.
Okay, it's pretty easy to get this motion mixed up with some other legal moves that sound kind of similar. So let's take a second to draw some really clear lines in the sand so we all understand what makes a motion in limine so unique. First up, let's compare it to a motion to suppress. They both try to get evidence thrown out, but they do it for totally different reasons. A motion in limine is all about fairness and relevance in the courtroom. Is this evidence just going to unfairly prejudice the jury? A motion to suppress, on the other hand, is about your constitutional rights. It argues that the evidence itself was gathered illegally, maybe through an unlawful search, and shouldn't be used at all.
And next, let's talk about a protective order. The big difference here is all about timing and audience. A protective order happens way earlier in the process, during what's called discovery, and it basically controls what information the lawyers have to share with each other. A motion in limine, though, is all about that final step, controlling what the jury actually gets to see and hear when the trial finally happens.
So after all this, why does this one kind of technical procedural motion matter so much? Well, because it really gets to the absolute heart of our justice system and our fundamental right to a fair trial. When you boil it all down, the motion in limine is a filter. It's a tool that's designed to make sure that a jury's verdict is based on the actual facts and evidence of the case, not on emotion or bias or some improper information that never should have been mentioned. It helps level a playing field, and really, it protects the integrity of the whole process. And all of this leaves us with a pretty fascinating question to think about. We know the motion in limine is powerful, shaping the entire trial before it even begins. But it has to make you wonder, if so much of the legal battle is fought and won behind closed doors before the jury even arrives, how much of a public trial is the whole story? And how much is a carefully curated performance?